If you buy foreclosures, you probably already know that many times lenders don't bother removing the former owner of the property who continues to occupy even after the judgment of foreclosure. I'm going to tell you about two actual cases where the purchaser sought removal, but in one of them, my client had an interesting option that made it easier and more cost-effective to remove the occupant. And that's the topic of this video. Hello again, everyone. I'm attorney Robert Flesses. It's been a while since I posted a video because I've been busy with clients. But my thanks to those who have subscribed, remained loyal to my channel, and found my videos helpful. But if you're new to this channel, you might want to consider subscribing right now, because if you do, you'll know where to go to get answers to your legal questions. Recently, I had a couple of clients come to me complaining that they purchased a foreclosure, then discovered that the former owner refused to vacate the property. My client tried to negotiate directly with the occupants, received promises from them that they'd leave, but the occupants failed to follow through. Well, in this first case, a client bought a foreclosure through an auction. The home was located on a really nice big lake. My client attempted to negotiate with the occupant to leave, but his efforts failed. So what did we do? My client had to spend money to file an eviction action against this occupant. And in my jurisdiction, eviction actions are usually heard before what's called a court commissioner. They don't have as much authority as a judge. If the defendant, and that's the occupant, contests the eviction before the commissioner, there are two things that can happen. One is for the commissioner to just refer the case to a judge and you have to go to trial. The second option is for the commissioner to issue a judgment for possession, grant authorization to execute the writ with the sheriff, but the defendant can appeal that one. He can appeal the commissioner's judgment and then it still goes directly to a judge. With either option, you have to go to a trial if the defendant contests. The defendant is merely buying time. Well, in this particular case, the occupant challenged the eviction, requiring the commissioner to refer the case to the judge. The defendant had no case, and his real intent, as we all know, was to delay his removal because he lived on a nice lake property. So we go before the judge for trial. As the plaintiff, my client gave testimony to prove that he was the rightful owner of the property. As part of the evidence, of course, we presented a copy of the sheriff's deed confirming his ownership rights. The defendant did not have an attorney, and he acted on his own. And his defense was really frivolous. He insisted that he didn't know that there was a foreclosure on his property. Right. And because of that, he didn't know that he had to leave because the bank didn't make any effort to remove him, nor did he receive any legal process from the lender to vacate until we served him with eviction papers. Under cross-examination, I asked him, "What do you think happens when you don't pay your mortgage?" He replied, "I don't know." I told him that they start a foreclosure action, which he knew, and as the owner-occupant, the mortgager, you by law in my jurisdiction get a 6-month redemption period to pay off your mortgage, and if you don't pay, then the court orders the foreclosure of the property. Well, this guy had a year on the property without paying. I told him that means you don't own it anymore and you have to get out. Well, this guy was playing dumb. And like I said earlier, most lenders don't bother removing the occupant. They just want their money from the sheriff's sale, and it's now the purchaser's problem to get the occupant out. I don't blame them. The judge found this defendant's testimony incredible and ruled in favor of my client and promptly issued a writ of restitution for the removal of the defendant. Well, after receiving the judgment, my client gave him one last chance to vacate. He didn't leave, so the sheriff was engaged and he was removed. The second case was much more easier because when the court approved the sheriff's sale during the foreclosure action, the court's order contained a provision that if the occupant refuses to leave, then the purchaser can petition the court for a writ of assistance to remove the tenant without any need to file an eviction. The judge would automatically sign the authorization allowing the purchaser the immediate right to go to the sheriff to execute the writ. What's the moral of my stories? Well, when you purchase a foreclosure, before you run and file an eviction action, check the court's order approving the sheriff's sale. You could look at that document to see if the judge inserted that type of language, allowing you to bypass the formal eviction process. I'll have more stories for you soon. I'm attorney Robert Flesses. Thanks for watching, and remember to subscribe, and I'll see you in my next video.